have a pretty big question to begin with, and is what is your vision of capitalism?
Well, my vision of capitalism includes an important role for market competition. I think, our capitalist system in the United States has been responsible for driving so much innovation and growth. But a key ingredient there has been making sure that upstarts and innovators and people with a good idea can get a fair shake. And if you're undertaking certain risks, be able to reap the rewards of that risk if your product or service is succeeding. And so I think that's a critical component here and why antitrust and anti-monopoly has been such an ingredient.
So imagine that I am a factory worker in Ohio, and I ask you, how did your tenure at the FTC change my life?
So it's a really important question, and actually a question that I kept top of mind during my entire tenure. In healthcare, we were especially active in taking on basically the illegal tactics that inflate drug prices. And so, because of the FTC's work, for example, asthma inhalers today cost less than they did 5 years ago, where asthma inhalers have been around for decades, but through various patenting tricks, the dominant manufacturers were keeping out generics from the market. And after we challenged those tactics, three of the four big manufacturers said they were going to drop the out of pocket cost from hundreds of dollars down to $35. The FTC's work has also made it easier to repair your own product. Through a whole series of lawsuits, we took on the illegal repair restrictions that mean that farmers can't easily fix their own tractors, or people can't easily take their phone to an independent repair shop and instead have to go to the manufacturer. This was an area where we had not seen much enforcement for many, many years, even as companies were switching more to services, and so therefore benefiting from repair being an increasing form of source of profitability. The FTC's work on labor markets was extraordinarily significant. I mean, we finalized a rule that would ban non-compete clauses. That is now being litigated, but the FTC's lawsuits already resulted in non-competes being dropped for thousands upon thousands of workers. We stopped major mergers that would have reduced competition in areas like grocery retail. The Kroger Albertsons merger, for example, would have been the biggest grocery merger in US history. The FTC successfully blocked that. We successfully blocked over half a dozen hospital mergers that would have resulted in various parts of the country paying more for hospital services, even as quality went down. And so I would say the agency really punched above its weight, given what a small institution we are, and really achieved win after win for the American people.
As I was reading up before this, I thought, everybody says they're pro-competition. You say you are, your foes say that they're pro-competition. And I thought there was a very ironic note in this idea that your effort to ban non-competes is somehow anti-competitive, which got me thinking about the way in which people use words. Silicon Valley, for instance, would say that they are very pro-competition. And yet you wrote in a recent op-ed that these companies have been arguing that the government must protect them from competition to ensure that America stays ahead. So how do you think about that, the use of that word competition, and how do you think different people mean it?
Well, non-competes are literally called non-competes. And so I think there's something slightly self-evident going on there. I think people are probably most familiar with the idea of competition from sports, right? When you're playing a game, there are certain set of rules. But within the confines of the rules, you're trying to win. You're trying to kind of beat the other team or the other person. And what we've seen is that through certain business tactics, firms can actually try to squash the competition or shut out the competition. And so get ahead, not by doing better, but instead by what you might in the sports context call cheating, right? Injuring the other player, trying to rig the level, the playing field in some way. And so, making sure you're really promoting fair competition, fair dealing is what antitrust is about.
What do you make of the off-voice throughout history argument that antitrust regulators should be hands-off because we need to see America succeed? And you wrote this in a recent op-ed that tech companies have been arguing that the government must protect them from competition to ensure that America stays ahead. And even Mark Cuban said a version of that, which is that breaking up big tech companies might put the U.S. at a disadvantage. So should that argument that America's well-being is at stake affect what an antitrust regulator does, that there's a bigger picture here, or should it not? And is it used often to deflect attention from the real issue, or is it used in good faith?
Yeah, I mean, I won't opine on kind of what are the motives of the people making these arguments, though oftentimes they are coming from the subjects of antitrust enforcement. And it's true, this argument goes back decades. I mean, when the Justice Department was initially preparing a lawsuit against AT&T back in the 1950s, we saw, them encourage the Defense Department to weigh in on how acting against AT&T could undermine the United States' national security. And so we've seen versions of those arguments made. I mean, I think what we've also seen is that a key driver of America's innovative spirit and a competitive edge internationally has been the fact that we are not just coddling our incumbents, and we are allowing kind of new upstarts and innovators to also get out ahead. And I think a system where you're instead allowing more effectively central planning by a handful of monopolists rather than forcing those monopolists to also look over their shoulder and make sure that they're increasing their speed if there are upstarts behind them. I think that there are real downsides there, and we've seen that economies that instead double down on the national champions approach, including Japan in certain instances, actually fell behind, whereas the US taking action against Microsoft, for example, ended up being really important in making sure that the market was open and that the upstarts, including Google and Facebook and Amazon, were able to actually scale rather than get squashed in the crib by Microsoft. I think the national security argument in the context of big tech is really fascinating, given just look at some of the entanglements and dependencies that these firms have, including in China. And I think we've been seeing more revelations, including recently from a whistleblower who had been at Facebook, about the types of accommodations that these firms have tried to make, especially to China, because of their market incentives. And so I think we should be very leery of assuming that, these companies are kind of patriots first rather than kind of profit maximizing, kind of shareholder responsive entities that are going to put their business interests first, even when that means kind of cozying up to nations that may not have their interests aligned with the United States.
So your foes simultaneously point out that that the FTC lost a lot of the cases that you brought, but also that you single-handedly destroyed the American merger economy and destroyed capitalism. So talk us through how both those things can be true, or if you would refute either one of them.
Yeah, I think some of the critiques have at various points been pretty divorced from reality. And, when I came in, it was true that for decades, the antitrust agencies had taken a more hands-off approach to market consolidation and to mergers and acquisitions. Take the tech industry, where we saw the big five tech companies make over 800 acquisitions over the period of a decade, with not a single one being blocked and just a handful even being closely scrutinized. In areas like healthcare, we have seen a huge surge in consolidation with higher costs and worse service as a result. Take an area like rental cars, where we now have three major players. Oftentimes there can be an illusion of choice because when you go to the airport, you'll see 6 or 7 brands, but those brands are actually just controlled by 3 companies. And when the FTC was reviewing one of those mergers, they decided, yes, there were problems, but they would allow it to go through as long as some of the assets would be divested to another company. that other company ended up going bankrupt, and the original merging companies ended up buying back those assets at a lower price. So the remedies that the agencies had been pursuing in some instances had failed catastrophically. And practically, this meant that in people's day to day lives, they had fewer choices, they were paying higher prices, workers had fewer employment options, and their wages were suffering as a result. And overall, our markets were more centralized and less open and competitive in ways that really do encourage entrepreneurship and startup and business dynamism. And so we decided that we were going to be much more skeptical, especially in the context of huge deals that would dramatically consolidate a market, and that we were going to be much more leery of remedies if they weren't actually going to fix the problem. And in both of those instances, we saw real results. We filed major lawsuits. We had a win rate that was over 95%. And most importantly, we created deterrence in the marketplace. I mean, one of the things that was most shocking to me was hearing from antitrust lawyers and senior deal makers that before the Biden administration, as they were contemplating deals, antitrust risk would not be talked about at all. And if it were, it would come up at the very end once the main factors had already been worked out. And if I'm a law enforcer, I want to make sure firms are staying on the right side of the law. And they should be figuring out right away if a deal that they're contemplating is illegal. And if so, they shouldn't pursue it. And so the idea that firms, as a result of the FTC's vigorous approach, were having to start thinking about the legal risk on day one rather than months down the line was a real positive.
So when I hear your answer to my previous question and to Bethany's questions, I feel that there is a lot that can reach ordinary human beings. So if I were a consultant for Kamala Harris, I would say you should run on the record of Lina Khan at the FTC, because after all, I'm sorry to say, the Biden administration did not have a lot of victories to run on, or at least on the popular front. And especially with the slogan Kamala for the people, you will expect that your agenda will become at the center of the campaign. But maybe I miss it. I didn't hear a squeak about that. If anything, there was some squeak of some of our founders who wanted to fire you. So why is that the case? And more importantly, is there a future for an antitrust agenda in the Democratic platform?
Yeah, I mean, I'm not a campaign strategist or a political operative, so I can't speak to the, specific decisions that campaigns made. But as a general matter, I think what we are seeing right now under the Trump administration is a huge set of concerns about concentrated economic power, about oligarchy. You have huge rallies being led by Senator Sanders and Congresswoman Ocasio-Cortez around the country, where you have tens of thousands of people coming out really upset and angry about the deep concentration of economic power, which sits upstream from so many challenges that we face in our day-to-day lives. So there are a lot of open questions about what the future is going to look like, what the future of the Democratic Party is going to look like. But at a grassroots level, I think we see enormous hunger from people for elected officials and for government to stand up for them, especially when it means taking on law-breaking corporations that on a day-to-day level are making their life worse off.
You had argued that, I think you've argued that Trump's firing of Democratic FTC commissioners is a sign of Trump protecting billionaire donors. And yet there's the Google case and the Meta case. Andrew Ferguson, your successor, has said that he was going to reverse Lina Khan's anti-business agenda and stop Lina Khan's war on mergers. And yet, do you see any common ground, or do you think what is happening now is a complete reversal of the policies of what you had accomplished? And then how much of your work can be undone?
So I think on the antitrust side, we've actually seen a striking degree of continuity. The Trump administration has agreed to keep in place the merger guidelines that we put in place at the end of 2023. They have kept in place the new Hart-Scott-Rodino form that we introduced, which is kind of in the weeds, but it's basically the form that companies have to fill out and the information they have to submit when they are pursuing a reportable transaction. We had introduced a form that was basically a game changer. Private equity in particular was very upset about it, but they've kept that in place. They are continuing with many of the lawsuits. The trial against Facebook, we're now in its second week. I think on the consumer protection side, because that's work FTC does as well, we have seen a major slowdown.
But when you mention, for example, Bernie Sanders, you mention more concerns about concentration of power and democracy in general, which are very legitimate, but maybe less of a concern for the average worker. While many of your victories have been obtained on a very traditional ground, in a sense, the stuff that you mentioned that matters to the average American is not some sophisticated theory or new theory, is just old-fashioned antitrust enforcement. And but I remember you were on our podcast many years ago describing the Brandesian approach to antitrust. And I would like to ask you, to what extent your tenure at FTC was more enforcement of traditional antitrust? To what extent was a new view of antitrust more Brandesian? And if you can point out for many of our listeners who will not be familiar, what is Brandesian about the new approach that you achieved?
Yeah, and I think sometimes, these terms get thrown around. I mean, the real key axes that I view as relevant is, are you being faithful to the law, to the laws that Congress wrote and what they were trying to achieve with them? And then are you being effective? Are you really responding to market realities as they exist rather than operating based on certain assumptions about how markets work or theories about how markets work that actually are pretty divorced from what's happening at a day-to-day level? I think there was a pretty radical effort in the 1980s to abandon the laws as written and to really adopt a more kind of vibes-based approach to antitrust, where it was just the writings of a handful of economists. One of the things we did was actually go back and look at what the law says, look at what all of the Supreme Court opinions say. And we found that in several instances, the agencies had actually been handicapping themselves and not making full use of the laws and the tools that Congress had given. And then the other big difference, I would say, is learning from the missed opportunities of the last few decades and learning from the instances where the agencies got it wrong. I mean, it's publicly known that the FTC investigated Google in the early 2010s and ultimately did not bring an enforcement action. One of the key assumptions, it later became public, that the agency had made at the time was that smartphones were going to be a real niche part of the market and that desktop was going to continue to dominate. Right. And so when you are making enforcement decisions based on assumptions about what's happening in markets that are getting it totally wrong, you really need to sit up straight and figure out what's going on here. And so one of the changes that I made at the FTC was making sure that we were regularly engaging with market participants. And that doesn't just mean like lobbyists and fancy lawyers, but actually means farmers and pharmacists and independent grocers and startups. We also made sure that the internal expertise of the agency was more methodologically diverse, right? Every tool and skill set can have its advantages, but also have its own blind spots. And so we wanted to make sure we were staffing up with IO economists, but also with labor economists, with accountants. I also started a new Office of Technology, which we quickly staffed up with data scientists, data engineers, experts in AI, people who could sit alongside our lawyers and economists. And especially as the tech companies were producing data and information, really help translate and figure out what's going on with this algorithm. And that was a game changer. I mean, several of the lawsuits that we brought included information, included theories that we were only able to pursue because we had technologists that were able to look under the hood and figure out what was going on.
At the latest Stigler Antitrust conference, there was one of your adversaries, Shaw Ether, who is the senior vice president of the U.S. Chamber of Commerce. And he said, oh, we respect Chairman Khan, we respect everything, etc. But these people were trying to change the antitrust without passing to Congress. And with a little bit of gut, he said, we're very democratic. And so we want this stuff to take place only when has the seal of approval of the representative of the American people. So what is your reaction to this criticism?
Well, look, I think the most radically anti-democratic action that was taken in antitrust was to decide that enforcers didn't have to enforce the law, right? I mean, you have laws like the Robinson-Patman Act, which goes back all the way to the 1930s, which the FTC and DOJ decided just didn't sound sensible to them. And so they just were going to stop enforcing it. I mean, that is grotesquely undemocratic and actually really threatens the rule of law. Similarly, we've seen efforts to import into antitrust values or words or standards that appear nowhere in the text of what Congress wrote, nowhere in the text of the opinions that the Supreme Court has been issuing. And so I think we were actually looking to undo a lot of the anti-democratic work that had been done in prior administrations to pretend that the antitrust laws are not actually about, checking against extreme concentrations of economic power and making sure that we have checks and balances in the commercial sphere through market competition.
Do we need new laws? Was there ever a moment at which you were frustrated by the limits of the existing laws? And do the existing laws, will they serve us well in a world of AI? Or does Congress need to be thinking about what actually new laws should make sense?
Certainly there's always an opportunity for clarification, for correction. I think we're going to learn a lot in the coming years, given that a lot of these big tech cases are now resulting in opinions from courts. And so Congress can look at, say, the verdicts being issued on Google and the future on Facebook and Amazon and figure out, are these laws fit for purpose? I think one area that we're going to have to keep monitoring very closely, where we also have cases in flux, is this issue of algorithmic collusion and what happens when it's basically these algorithms that are facilitating effectively price fixing. We've seen, really troubling allegations against this company, RealPage. We've seen similar lawsuits in the context of hotels, where basically the defense is arguing that there isn't really collusion happening because the algorithm, for example, is just recommending that these hotels or landlords use those prices. That, for example, is an area where I think Congress would need to weigh in.
We have very sophisticated listeners, but I wonder how many of our listeners actually know what the Robinson-Patman Act is. In fact, I recommend our listeners to send an email for those who really knew before this podcast. And we're going to draw some T-shirts as a present. So can you explain to our listeners what is Robinson-Patman and why is important to enforce it today?
At its core, it prevents large retailers from securing special terms that are not being made available to other players. And if major retailers are, for example, asking for quantity discounts or volume discounts because of the efficiencies and the cost differentials that are resulting from that, that is fair game. But what they're not able to do is just use their raw muscle and bargaining power to say, I want you to give me a better deal than that smaller store down the road. And so this was a law that has stopped being enforced. And I would routinely hear from independent grocers and wholesalers that the terms that they were being offered by big suppliers were actually higher prices than what is on the shelves at the big box stores at the retail level, which is just shocking. And especially for rural areas, the lack of enforcement of Robinson-Patman has been pretty devastating. There's research and reporting actually drawing a line between the drop in Robinson-Patman enforcement and the rise of food deserts. And so it was a top priority to reinvigorate this area of law. We brought two lawsuits, one against Southern Glazers and the other against Pepsi. Both of them are pursuing, and the agency just defeated Southern Glazers' efforts to dismiss the lawsuit.
The Wall Street Journal published over 80 editorials criticizing your approach. People called for your firing, from Reid Hoffman to Musk to Barry Diller. Were you surprised by the extent of the pushback, and did it affect you at all? And I know they're kind of two different questions, but they're sort of the same.
Yeah, I mean, I wasn't too surprised. I think what was striking was just seeing that, for a certain class of company or business executive, there was this basic level of feeling offended that the law was being applied to them and that they had to follow the rules. And, it is true that at an agency like the FTC, it is very easy to say, okay, I'm going to focus on the fraudsters and the scammers and these fly by night guys who are doing a lot of harm, and look the other way when it comes to the big eyes. And I think one thing that I wanted to avoid was these kind of two tiers of justice, right? Where we kind of bring down the hammers on the small businesses, but go pretty light on the big businesses. And I think that kind of even-handed approach to enforcing the law is really critical, because not doing that, I think, contributes to real cynicism and disillusionment with government, to think that, there's special access and special favors and sweetheart deals that are available to some and not others.
In the past, FTC chairs, after they step down, they go and make millions at private law firms. So I have two questions for you. First of all, did you receive very generous offers? And number two, are you taking them or not, and why?
I did receive some solicitation from law firms, which was interesting. I have not pursued them. I'm back in academia, and I'm really focusing on kind of mapping out the next phase of this movement and work, both through scholarship and research, but also through making sure that we're training and providing support to the next generation of talent.
Jonathan Cantor has harshly criticized the conflict of interest between many academic economists, that on the one hand opine as academic economists, on the other hand are usually pay expert in many antitrust cases, even on retainer by many of the large big tech firm. Do you agree with him on this front? Because you're being silent on this issue.
I mean, I think the issue of academics simultaneously serving as consultants and not openly disclosing that is a major problem. I think it's also a bigger problem at the level of knowledge production and research, right? If you have a vast majority of, say, antitrust legal scholars that are actually also being hired by the monopolists to opine and to direct their research in certain ways, I think it just can entirely change the trajectory of what information and research is even being produced in the first instance, and really deprive the public of all of the benefits that are supposed to come from kind of academics and scholars that are pursuing those lines of inquiry in a way that isn't conflicted or corrupted by some of those other forces. So I think this is absolutely a big area where we need some serious reforms and guardrails.